Well, good evening, everyone, and welcome to our latest edition of our webinar series here at the Greensboro History Museum. I'm Rodney Dawson, Curator of Education here at the museum, and I would like to let you know this conversation is made possible in part by the Greensboro History Museum, Inc., the City of Greensboro, North Carolina, and the Libraries Department. So any views, findings, or recommendations expressed in today's program do not necessarily reflect those aforementioned entities. And now we're extremely pleased that you are our guest today. Thank you for taking time out your busy week to join us. And if you'll take the time to view the bottom of your screen, you'll see that Q&A icon. By selecting this option, you can type your questions in for our panelists. Once you've typed in your questions, just hit the enter button. We'll be watching it for questions, and we have reserved the latter part of our program to field those questions. And this evening, we welcome our lone panelist for the webinar, who's no stranger. He participated in our Remembering a Lynching webinar back in August of 2020. But at your convenience, you can see any of our previous webinars. You can also view this one, which will be made available on YouTube immediately after this session today. You can go to greensborohistory.org and select the YouTube icon, or go directly to YouTube and just type in Greensboro History Museum and you'll be able to see it. I alluded to it just moments ago, but today's panelist is the attorney James P. Mays. Welcome back, Mr. Mays. Mr. Mays has more than 20 years of experience of working on educational and cultural exchange programs for the United States Department of State. And as a professional member of these public diplomacy initiatives, he has met and established relationships with legal professionals from around the world. Just off mic before we started, he was connecting me with someone else. So I'm looking forward to tonight's discussion about police qualified immunity. And I'm learning a lot now. There's so much more to learn. So we had to bring in an expert, what I call a content expert. So thank you, Mr. Mays, for joining us.
Well, thank you. And it's a pleasure again to join you and join all of you out there in our webinar audience. I want to talk informally tonight. I hope not to go through these slides too quickly or make my comments too technical, but please feel free to submit questions and we can go back over anything that you might have an interest in. Tonight's discussion is about qualified immunity as it pertains to policing, law enforcement. And the question is, does it shield police from accountability? And this is one of a major discussion that's going on in our communities across the country. But before we get directly into that, there are two observations that I want to make. The first observation is this: oftentimes when you talk to people about American democracy, people like to point out, well, yeah, we're a democracy, but we're really a republic. And the thing that I want to point out, or want us to think about, is what distinguishes us as a republic. There are many republics around the world. There's the People's Republic of China. There's the North Korean Republic. There's the Islamic Republic of Iran. So there are many different types of republics, but the thing that distinguishes this republic is that we're a democratic republic. We claim, at least in theory, that democracy distinguishes us from many of these other republics. And that's an important point. The second point that, or observation that I want to make is that this issue of qualified immunity is deeply rooted in the identity or the DNA of our country. We, as a nation, have a story that it goes back to our very beginnings. And that is that we are a government that is constituted or created by the governed. In other words, the citizens give consent to the government. And the second point is that the citizens reserve the right to hold that government to account for all of its actions. And this is not only embedded in our Declaration of Independence, in the Constitution with the first 10 amendments, but also in all of our law, both case law, statutory law. So as we talk about qualified immunity, it's important to keep in mind that we live in a nation where the premise is that the government is a government of the people, it must be for the people, and must be accountable to the people. And secondly, that those things are protected, our rights are protected by law, beginning with the first 10 amendments of the United States Constitution, the civil rights laws and amendments to the United States Constitution, and the statutes. So having said that, and I want us to keep that in mind, the focus, then our focus tonight in this discussion, and let's see if we could advance the slide here. Okay. The issue focus tonight, the doctrine of qualified immunity as applied to police, law enforcement, is an issue of accountability. The primary focus is on professional misconduct under the color of state law. Again, I just want to underscore this point. If you go read the Declaration of Independence, right, and read the grievances that are outlined, the grievances were based upon the colonists' idea that the crown, the king, the monarch, right, committed misconduct or illegal acts against the colonists and did so under the color of law, and that infringed upon their rights. So the concept and practice of immunity, let's look at that for a moment. Immunity is an exemption granted by common law, statute, or government authorities from a legal duty, from a penalty, or a prosecution. And we just lifted this from the U.S. Legal Dictionary. It's a working definition that we can use throughout our discussion tonight. It is an exemption, meaning that the parties that are responsible are not held accountable to a duty that was owed. They are not penalized and they're not prosecuted. There are generally two types of immunity. One is absolute, and I give you some examples here. We have, as many of you have heard about, diplomatic immunity, immunity that legislators have when they are legislating. Judges have immunity, more falling in the line of absolute immunity. And then there's limited or qualified immunity. And some examples of that are what we're going to talk about tonight is police and prosecutors. Now, with prosecutors, just as an aside, what we want to distinguish is that prosecutors are immune from the acts that they do during litigation, but they're not immune from acts that are committed during the investigation of crimes. All right. The concept of immunity is applied in this context, or in the context of United States law and government, has its historical origin in English common law and is related to, and we really don't have time tonight to get into these ideas in history, but the crown, the monarch, was considered to be immunity. A very popular saying was that the king could do no wrong, and the king could not be held accountable to Parliament or to the common or to the people. And it was also related to divine right theory, because if you rule because if you're God's vicegerent on earth, you're above the law. Now, it's also related to statutory law. We have statutes, and we'll talk a little bit about this when we talk about sovereign immunity, right? But there are statutory basis for immunity, and there's also a case law basis for immunity. So where does this doctrine of qualified immunity come from as it relates to policing? Well, there's one case that is cited as the origin of qualified immunity as it relates to policing. In this case is Pearson v. Ray. Now, it's interesting that many of the cases that one will read about qualified immunity, particularly as it relates to police power, right, are related to our history of civil rights litigation in this country. So in Pearson, basically, the facts behind this is that there were a group, integrated group of clergymen that were protesting segregation in the South. And in 1961, they were in Jackson, Mississippi, in Hinds County. They walked into a bus station in the waiting room and began to pray. And they were arrested. And they were arrested under a statute that outlawed loitering. So it was an anti-loitering statute. And these statutes have a notorious history in the South, as well as in some other parts of the country, but particularly in the South. And they eventually claimed, they filed a lawsuit that says that this statute and being arrested for violating this law deprived them of their civil rights. And they also claimed that they should be able to hold the police officers personally accountable under a statute, 42 United States Code, Section 1983. And we'll talk about that a little later on. But just for our purposes here, that statute clearly states that if a state actor, a state agent, right, does an act that violates the constitutional rights of a citizen, that the aggrieved party, that citizen, can hold that state actor accountable, personally liable for the action that was taken against them, especially if that action was taken while that person asserted that they were doing so legally. Now, having said that, the Pearson case, the Supreme Court ruled, and they didn't get to rule until 1967. We're talking 6 years later. And a lot of interesting things that happened during this period. But those of us who remember the 60s and all of the things that were going on, there were many cases of this type because people understood, and in fact, Section 1983 was passed in 1871 to protect the civil rights of African Americans. But here are 2 points. The court said that the police in this particular case should not be found liable under 42 USC Section 1983 because they are entitled to a defense of good faith belief, and that this officer or officers acted with a good faith belief and therefore did not intend to violate the civil rights of these persons. They were just implementing the law as it was written. Now, having said that, the court's decision overturned the long-standing legal precedent. And this is what that legal precedent is, and this is what we need to keep in mind. That the United States Supreme Court held for many, many years that government agents were strictly liable for constitutional violations. They gave rise to common law torts, strictly liable. The strict rule of personal official liability, even though in many times it was considered to be harsh, right, was enforced by the United States Supreme Court. In 2 cases to look at, Myers v. Anderson, and also Monroe v. Pate, another 1961 case, and we'll talk about those cases later. But this is what changed. This case, Pearson, changed this long-standing precedent. Let me take a moment to recap. The long-standing legal precedent was that if you acted under the color of state law, you were a government official, and you injured a citizen, you were held strictly liable. That was the law. Pearson changed that. And it said, first and foremost, that if that official committed that act and it was a good faith mistake, meaning that they didn't know or understand that the act they took violated the constitutional rights of an individual, they should not be held liable. That's the change. Now, what happened after that? There were a series of cases that advanced this concept of qualified immunity. Now, why do we say it's qualified immunity? The officials are not absolutely immune, but they can be held immune from prosecution, from accountability, if certain conditions are met. And one of those conditions is good faith. In 1982, the Supreme Court returned to this issue in the case of Harlow v. Fitzgerald, and they further developed it. And it said in this Fitzgerald case that this subjective test of good faith is not necessary. That instead, all the defendant individuals should be asked to do, right, is to show, or let's change that statement, what the plaintiffs need to show is that this act that took place, this unconstitutional act, has been deemed unconstitutional, and that it's an act that a reasonable person would or should have known. And the result of this is that we no longer ask the question, well, did the actor make a mistake? Or did they not know, right? The burden shifts to the plaintiff. The plaintiff must show that a reasonable person would or should have known. Now, the result of this was that there was a different kind of test that was created. The new test that came out of this case was that one, the first thing the plaintiff had to show is that there was a constitutional violation. And then secondly, and I quote, they have to show there is a clearly established legal precedent that the legal action sought was actionable at law. In other words, that they had to find a case that had been tried that matches their case on all corners, on all fours, meaning that it had to match the same legal issue, the same facts, that all of these things had to line up. And if you found a case that was that clearly established the legal precedent that this kind of action could be prosecuted, then you can go forward with your case. Now, you can imagine the difficulty, and we don't have time to get into all the different tests of this new two-pronged test, right? But no longer can the defendant rely on good faith, right? The burden shifts to the plaintiff, and they have to show, one, that there's a constitutional violation, and two, that there's case law that substantiates that this can be a case that should be litigated. Another case that's important for us to take a look at as an example of how this operates, in the case of Baxter v. Bracey, a man was arrested by the police for breaking and entering various residences. They caught him in the basement of one such house. He was sitting on the floor and he had his hands in the air, signaling that you got me, come arrest me. What they did was to allow one of the police dogs to attack him. They sued under 42 United States Code, Section 1983, saying that this was an unreasonable seizure. And they cited an earlier case that had found it was that they said this is a clearly established precedent where a person who was arrested and bitten by a police dog, and in that case, the person was laying on the ground with their arms spread out, and then that person was attacked by the dog. The court found that there was a constitutional violation and held the police liable. In Baxter v. Bracey, they said, no, this is not exactly clearly established legal precedent. Why? Because in that earlier case, the plaintiff was laying on the ground with their hands out. And in your case, You were sitting on the floor with your hands in the air. And therefore, they said to the plaintiff in this case, your case is not clearly established, and we rule against you. Subsequent cases. Qualified immunity defense must be made early in the trial, and you must employ the two-pronged test, which I just went through. Additionally, right, in Pearson v. Callahan, the court went further. This is a 2009 case with Justice Scalia writing for the majority in that situation, said, you know what? To do the two-pronged test takes a lot of the court's time and expends a lot of resources trying to determine whether or not there's a constitutional violation. Let's go straight to the second prong of the test to see if there's clearly established law. And if there's no clearly established law, let's dispense with the case and move on. And so the two-pronged test was set aside, and that's where we are today. So, what does this all mean? The 14th Amendment to the United States Constitution and the statute 42 U.S.C. Section 1983 were passed to protect citizens from federal and state abuse of their constitutional rights. This includes police misconduct. The historical precedent was to hold government officials and their agents personally and strictly liable for any harm or action depriving citizens of their constitutional rights, including life and liberty, including police misconduct, where people may lose their lives, where they may lose their property, where they may lose their liberty, to hold them accountable. But while the courts continue to recognize that citizens can hold the government officials liable, in other words, they haven't abrogated 42 U.S.C. Section 1983, but what they have done, and it's important to understand that qualified immunity is the court-made doctrine. It was not created by Congress. It is not in the United States Constitution. But in 1967, the Supreme Court of the United States said that we're going to dilute the ability of citizens to hold government officials, of which police are, accountable for their actions. And in effect, the extent to which qualified immunity has been used, it has provided a shield for egregious conduct by government officials and in particular, police officers. Now, proponents of qualified immunity say it protects government officials from harassment, from distraction, and liability when they perform their duties reasonably. They said it frees officers to properly use discretion in the field. They say it protects the private assets of the officers from litigation, from lawsuits, costly lawsuits. The fact that it is a judicial doctrine does not make it legally invalid. And they also argue that it's the only real protection for law enforcement provided by the law. Critics of qualified immunity say that it is a judicial-made doctrine that has no basis in the common law or statutory law. 42 U.S.C. Section 1983 does not mention anything about immunity for government officials or agents. They say as structured and implemented, it precludes a remedy for civil rights plaintiffs by providing almost absolute immunity for bad actors, even when constitutional violations are established. Let's elaborate on that just a little. So even when you take a police officer to court and can prove that there was a constitutional violation, it is almost impossible to find a clearly established legal precedent on all fours. And therefore the case is thrown out. They also argue that it denies justice to victims of egregious conduct and that it undermines public trust in law enforcement. So, what are some of the recommendations? So let me just roll back. I may have been talking too quickly, and let me tie this very closely to what we mean or how it's related to policing. It is typical when there is some police conduct that a citizen believes violates their constitutional rights. And let me go back to this Monroe case that I cited earlier. Said I would come back. Monroe v. Pape, which was decided by the Supreme Court in 1961. In 1957, the Chicago police at 5 a.m. in the morning entered into the house of an African-American family, rousted them out of bed, made them all strip naked, and stand in the living room while they ransacked the house. They did not have a warrant. They subsequent to entering the apartment, seized the man of the house and took him downtown and subjected him to interrogation. They sued under 42 United States Code Section 1983. In the Monroe v. Pape, now this is 1961, in that decision, the Supreme Court of the United States established the fact that the constitutional rights were violated, and Officer Pape in particular, and several other Chicago police officers were personally held liable for violating the constitutional rights of this family. That's how it's supposed to operate, right? But it doesn't now under qualified immunity. There are those who say that to cure or to remedy this problem of qualified immunity, that it should be terminated. The court, the Supreme Court of the United States, should overturn this rule, this doctrine, because there are many, and there are hundreds of cases. Of course, we didn't have time to go through them tonight, but there are hundreds of cases where people have brought suit. There was a recent case where a person who was mentally ill had to go to a hospital. They were suffering from pneumonia. They didn't cooperate with the hospital officials, who called the police, who came and tried to subdue the man and shot and killed him. Now, again, the family of this individual brought suit under 42 United States Code, claiming that the killing of this individual violated his constitutional rights. The Supreme Court found that no, under qualified immunity, the officers were not responsible for the act. And I could give more examples. I want to point out that this doctrine of qualified immunity in the Pearson decision came out a year before another infamous court-made doctrine, articulable reasonable suspicion, which replaced the probable cause standard, was also created by the Supreme Court. Nevertheless, right, there are alternatives that can be used to protect the interests of police. Now, I agree that officers that go out into this out into public, into danger, should have certain protections. In many cases, they're protected because the local jurisdictions indemnify them, so they can't be sued or have their personal assets seized. Also, if we had viable civilian review boards, we can protect the interests of policing. But limiting or not holding officers accountable for the acts that they made, right, undermines the trust that the public has in law enforcement. And then finally, there was some suggestion that we could amend 42 USC to prevent abuse of the protections of immunity and to ensure that there's some accountability. And and the last point I want to make on this is that this is not a liberal or leftist point of view. Qualified immunity has been criticized from organizations on the right, for example, like the Cato Institute, as well as people in the middle and on the left. So to characterize this evaluation and criticism of the doctrine of qualified immunity does not fit neatly into the political spectrum. And so with that, I'm going to turn it back over to Mr. Dawson and let him prepare us for questions and answers.
Yeah, thank you, Attorney Mays. And as you said, if you have any questions, just go down to the bottom of your screen, type them into that Q&A icon. Should be almost directly in the middle or next to the chat feature, but type it in the Q&A and not the chat feature. But I did get some questions that were emailed to me earlier. And one of them you may not be able to answer, but I'm hoping you can get us ballpark it for us. How often is qualified immunity in your time here? How often have you seen it? I'm saying a 5-year span used in Greensboro.
It is always operating. And so because it's a court doctrine, the attorneys representing police officers know that that is an option. And they know that going forward into a trial, that the plaintiffs who are bringing suits under 42 USC, that they have to first show that there's a constitutional violation. And secondly, that they also have to bring a clearly established legal precedent. So it is standard procedure for those officers defending, those attorneys defending officers use in that defense. Okay,
thank you for that. And then the second one, can you explain the difference? And I know somewhat, but you're my content expert. In North Carolina, explain the difference between self-defense and the Castle doctrine.
Well, here's the thing. You don't have the absolute right to defend yourself, so to speak. In other words, there are questions that are related to the amount of force that's used. So say, for example, somebody comes at you with a pencil and you respond with a gun. That is not a like response. So we always have to consider the amount of force that's used to defend yourself. Secondly, the doctrine used to be that you could always use deadly force to defend your castle, so to speak. That if somebody comes to your house and they break in, say to steal your TV, do you always have the right to use deadly force to defend your property? That used to be the case, but is no longer the case. So that has been distinguished. So and we see the same thing. The case escapes me right now, but it comes out of Kentucky, where police can't use deadly force to subdue a fleeing felon. So the fleeing felon rule that you could shoot somebody because they may get away has also been abandoned. So what we see is that these doctrines are changing over time because there are questions of equity here that apply. If someone comes in your house and they attack you, let's say with a knife, and well, that's a deadly weapon. In that case, you can respond with deadly use of force. But if they come in and say it's someone who is 5'6" and 102 pounds when wringing wet, and you're 6'2", nice buff, 230 pounds, right? We take those things into consideration. Now, the other part about the castle doctrine is when do you have a duty to retreat? And that's a litigated point. It used to be that you didn't have a duty to retreat in your house. Okay, I'm in my house, and you come in and, I didn't invite you, right? I can shoot you dead at the threshold, But if I can retreat to a part of the house and remain safe without being attacked, in some jurisdictions, they consider that to be a duty that you have. So the council doctrine has evolved over time. Originally, you could shoot to kill, right, and maim if somebody came into your castle. That's not the hard and fast rule today.
Thank you. And it's my understanding that the tassel doctrine in North Carolina does not apply to bail bondsmen or police officers.
Well, because there is, there are certain, all right, so first, let's distinguish your question. If the bail bondsman or the police officer is in their home, okay, and you ask, well, do they have do they either have a duty to retreat or can they use deadly force, right? The presumption is that because of their training and because of their experience, they should be able to handle the situation differently. Where you and I, ordinary citizens, I'm not trained as a law enforcement officer, right? What happens when somebody comes into my home, right? How do I respond? And that's distinguished from what those persons do. Right?
Okay. Now I want to get to some questions. And remind you, go to the Q&A at the bottom of your screen and you can type it in. But a couple of questions here. Who decides if the GPD, the Greensboro Police, get qualified immunity? Is it the police department, the chief, is the union involved, or is it city manager or city council?
No, it's a judge made, Supreme Court ruled on this and recognizes it as a legitimate bona fide defense that any law enforcement officer who's facing this type of suit can use. And so it's not something that's bestowed by the city manager, it's not bestowed by the police chief or anyone. Is that if I'm an officer and I get accused of violating someone's civil rights, by law, I have the right to use qualified immunity defense. It's there for me to use. Okay.
And we can field a few more questions if you type it in the Q&A. Another question here. One of our attendees was at an event where a Greensboro policeman was speaking. Mm-hmm. It was about 2 years ago, I'm reading. In the audience, the police officer told the audience that their police are only taught to shoot to kill, which is something I've heard too. They used to teach us that in the military.
Yeah.
But there is no shooting to debilitate someone. So who decides that? How is that determination made?
Yeah. Now, see, this is an issue that goes back to the police academy and what they're trained to do, and that can be changed. This is what when we talk about professional standards, there are national organizations that develop these kinds of standards. When police go into training, in-service training, when they're developing rules of engagement, there are people on the police force. For example, the police have lawyers, and they look at the law to see what is allowable under the law. The use of force continuum that was designed by police officers. So it is a standard of engagement that is created by police. And the only time that we get to look at this is when there is something that we consider to be egregious that occurs. For example, when a police officer shoots an unarmed, mentally ill person. And the question is, why did they engage that way? Because that's what they were trained to do. What the public needs to do is to say, we don't want that as a standard. And in fact, we don't want police officers trying to intervene in cases where the issue is mental illness, because they're not trained mental health professionals. They're law enforcement. And so we need to seriously look at what we ask our police officers to do. And I would certainly advocate that if we want police officers to intervene, for example, this situation in Rochester, New York, with the individual that was shot last year, it was a mental health issue. And the other one in Philadelphia, the family pleaded for the police, please don't shoot him. And so we need to work with the police to help devise mechanisms to respond. But in today's world, we call on the police for everything, and that's wrong. And so the police and the community need to get together and have this discussion to craft the kinds of rules of engagement that work for everybody's benefits.
Well, with that, I want to say thank you very much for participating in the kickoff to our webinar series, Police, Community, and Justice. This is just part one, and I'm gonna have Glenn tell you a little bit more, but we got part two next week, which you'll be back, and we'll be joined by Deputy Police Chief Johnson, because he's over community relations for the Greensboro Police Department. So Deputy Police Chief Thompson. And so he'll be joining Attorney Mays next week. So please register. You can go on our website, greensborohistory.org, and just register for that one and spread the word. Everything we do is free, but we love great attendance, because that gives us reasons to keep going and keep providing this program. And then I'll go ahead and mention on February 23rd, Attorney Mays will be back along with a local educator. We have an administrator from Guilford County Schools, and we have the deputy police chief that handles the school resource officers. So our topic is school resource officers and the school to prison pipeline, and what we can be done to improve upon it. So that's on the 23rd. And again, on next week, we're talking about community relations. So I want to thank you for that. And Glenn, I believe you got some things you want to mention for us as well.
I do. Thank you, Rodney. Glenn Perkins, also from the Greensboro History Museum. Been enjoying this such an interesting topic, and appreciate Mr. May's expertise and sharing and breaking down all those cases for those of us who don't have that legal training to really understand how those questions that work their way into law can really have an effect on things that we don't even think about or we don't even anticipate from day to day. If this conversation has been interesting to you, and I hope the upcoming webinars will be, and it's something you want to talk about more, I want to invite you to register to take part in our series of democracy tables that are coming up. It's a project that we're doing with UNCG Communications Studies Department, and an invitation for folks to come and gather in virtual spaces, because that's what we have to do right now, to talk about issues of civic engagement that are important to Greensboro right now. And the one that is going to be starting in February, on February 24th, is Police, Community, and Justice. So we'll be talking about people's experiences with law enforcement, as well as people's visions for maybe what law enforcement can look like in our community. We did a series of these around voting in the fall, and it was just a great opportunity to really hear a range of experiences. So I do want to invite you to take part in that. You can go to greensborohistory.org greensborohistory.org/democracy tables. Here, I will drop that into the chat as well, to sign up for one of the conversation sessions that we'll be having. Then we're going to be doing another series on housing and equity later on. So again, thanks for letting me make that plug here at the end of the program.
Absolutely. Glenn's the man that makes things work around here. So thank you, everyone. Please join us again next week. And Attorney Mays, I look forward to seeing you next week. I'm about to buy you some, when COVID slows down, I'll treat you to lunch for all.
Okay. All right.
Okay. All right. Thank you, everyone. You have a great